I remember correctly, you have stated or posted that the fundamental root cause of all of this is the bar association. Am I not correct on that?
Well, I would say it's not so much the bar as much as our misunderstanding of what American legal philosophy is. You see, the big difference is that in England you have a monarchy, right? You have a king, and that king has the authority to be able to delegate his powers to his agents. So in England, a judge speaks the law. Whatever a judge says in England is the law because the king has delegated that authority to his agents. He's delegated his power for his agents to speak the law. So in England, judges create the law. The people don't, the judges do, right? Because the king makes the law. But here in America, it's a little bit different because here in America, we, the people, did not delegate the power for judges to make law, right? We didn't do that. It's not in the Constitution. In fact, the separation of powers, when you look at Article 1, Clause 1, it says all legislative power is vested in Congress of the United States. So the judicial branch has no authority to create law, right? Because that would be legislating from the bench. And we know that they can't do that. All legislative power is vested in the people through the legislative branch. That's what we have here in America. The problem is that is that the law that the people create is not the foundation that judges go to determine, the outcome of a dispute. Instead,
Right.
they go to what they call case law, right?
Right.
So case law is nothing more than a judge made ruling that judge called law. But the question we have is how can judges create law when they can't legislate, when there was no delegated authority to the judicial branch to be able to create law? So if the Constitution of the United States is the foundation, as it's supposed to be, right, and that's the object of which every public official's fidelity is bound. You take an oath to the Constitution. That's the object of which your fidelity is bound to. Then it would seem to me that when I have a dispute or a constitutional challenge and I say my rights that are constitutionally protected have been deprived, that they would go to the object of which their fidelity is bound. They would go to the Constitution to determine was his rights violated. And they don't do that. Today, they go to judge made rulings, not the Constitution. So the object, that the foundation is not the Constitution, the foundation is the flawed decision of the man that came before them. That is an English judicial philosophy. It is not an American judicial philosophy because here in America, we did not give the authority for judges to create law. A judge made ruling is just that. It's a ruling, but that ruling must be consistent with the positive law because every judge here in America is tethered to the positive law created by the people. So we don't
Right.
live in a world that is based upon the rule of law because the rule of law would be what does the law state? What is written in the law? And we're going to determine the outcome of a dispute based upon what the law states. Instead, we live in a world where judges determine what the law is based upon their own social, political, or public policy. That is not a legal, a government of laws where the Constitution would be the foundation. Instead, that's a political theory that's known as legal realism, where judges determine what the law is. That's what you have in England. That's not what you are supposed to have in America. And that's actually what I'm trying to fight here, is that all of this bullshit that judges have created, right, where they called case law is not law. It can't be law because judges can't legislate. So uh, a good example would be the indictment by a grand jury, which is a big part of the work that we're doing. You see, the Constitution of the United States, Articles 1 through 7, creates the obligations of our government. Then you have the Bill of Rights, which are the first 10 amendments. Those first 10 amendments, they were never to be interfered with in any manner. They were never subject to dispute or typical legislative. Those were rights that were guaranteed to the people that were to never be interfered with. So clause 1 of Amendment 5, certainly part of the Bill of Rights, I don't think anybody is denying that. What it says that no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So that's clear. You cannot be held to answer. In other words, you can't be arrested and held to answer for the crime without an indictment by grand jury for a capital crime or an infamous crime. Capital crime is any crime punishable by a death. Infamous crime is any crime that's punishable by more than 1 year imprisonment in a penitentiary. So you can't be arrested and held to answer for those crimes without an indictment by a grand jury. However, today, right now, as we speak, there's more than 700,000 people currently in prison here in America that never received an indictment by a grand jury, despite the fact that it's required by the Constitution of the United States and enumerated for all to see. The reason why is because in 1884, the United States Supreme Court came out and said, state of California, you don't have to do an indictment by grand jury in a case called Hurtado versus California. So the Supreme Court of the United States came out and said, yep, Constitution says it, but California, you don't have to do it. And then when they made that ruling, that set the precedent that said none of the states had to do it. And as a result, a number of states immediately wrote into their Constitution a provision that says, we're not going to do an indictment by grand jury. And now you have states such as Washington, such as Pennsylvania, such as Michigan, North Dakota, Connecticut, that do not conduct a grand jury, despite the fact that the Constitution says you must have an indictment by a grand jury before arresting someone for these offenses.
Kidding me? How long has this been going on?
1884.
No. I mean, how long have these states been sending people to prison without a grand jury indictment or even investigation?
So it depends. 1884 was when California did it. 1887 was when Washington did it. 1984 is when Connecticut did it. 1987, somewhere around there, is when Pennsylvania did it.
Okay.
I don't remember North Dakota, but that's those. There's 13 states that do not conduct a grand jury at all. Don't do it. Outright say we're not going to do what the Constitution of the United States of America says we have to do. I'll tell you that another 28, the rest of them, another 27 of them, they allow their prosecuting attorneys to charge by what's called information or indictment by their discretion. So in other words, the state of Oklahoma, for instance, what it says in its Constitution, Article 2, Section 18, says that the prosecuting attorney can charge by information or indictment as prescribed by law. The prosecutors in the state of Oklahoma believe that means that they can choose, am I going to use information, which is not an indictment, right? But I'm going to use information as a charging instrument or indictment as the charging instrument. And 99% of the time they choose information, right? By their discretion. But unfortunately, that particular law that Oklahoma has, what it does is it allows for the prosecuting attorney to decide who gets a constitutional right and who does not, which is clearly a violation of the Equal Protection Clause, a violation of Article 4. Never can a public official decide who's protected by the Constitution and who is not. And that's the majority of the remaining constitutions. But nonetheless, the issue here is that the Constitution of the United States of America requires an indictment by a grand jury. So how is it that in 1884, the Supreme Court of the United States of America comes out and says, California, you don't have to do it? How is that constitutional when the Supreme Court of the United States amended the Constitution through a judge-made ruling that they erroneously called case law, and they amended that Constitution in a manner other than what is prescribed within the special amending procedure of Article 5? Because the Constitution says the way that you change it, and it has nothing to do with the judicial branch. The Supreme Court of the United States cannot deem the Constitution unconstitutional because the basis of the comparison would be the Constitution. So what happens here in 1884 is a branch of government that has no constituted authority to create law. They created an amendment to our Constitution of the United States of America in an other than lawful manner by overstepping the separation of powers, legislating from the bench, and then they directed all the states that you don't have to do what the Constitution requires you to do. And all of the states then believed, the Supreme Court said, well, that sounds good to me. And they started writing into their constitutions, such as Washington, Article 1, Section 26, says no grand jury shall be drawn or summoned in any county. So in the history of the state of Washington, ever since 1887, when they created their constitution, they have never convicted a person legally and lawfully consistent with the procedures and processes codified in the Constitution of the United States for the adjudication of crime. Never once, right? And that's a big, big deal, right? But it brings up the question here of what is the role of these states within our system of government? You see, the system is arguing with me about this in two separate ways. They're saying, one, well, the Supreme Court made a ruling that says we don't have to do it. Therefore, we don't have to do it. My issue there is, does the Supreme Court have the constituted authority to be able to alter, amend, or destroy any of the provisions that guarantees the Constitution? They do not, because the special amending procedure of Article 5 dictates the way in which an amendment must be done, and it has nothing to do with the Supreme Court of the United States. It has to do with the people ratifying the Constitution, the constitutional amendment, through an authentic and explicit act of the people, right? That's the way it's done. The people change the Constitution, not the judicial branch. That might be the way it's done in England, right? That might be the way that the king does it, but not here in America. Because here in America, according to Clause 1, Article 1, all legislative power is vested in Congress of the United States. So the Supreme Court cannot create law, right? They must obey the positive law created by the people, and they cannot amend the supreme law of the land. So the first issue is does the Supreme Court of the United States have constituted authority to be able to amend the Constitution in an other than lawful manner? And the answer is no. So then the next question is do states have the right to enact their own alternative legislation, substitute it for the guarantees of the Constitution, and then go out and enforce it as though that's constitutional? Right. It doesn't matter why the states may enact that law. It doesn't matter who told them that they can enact that law. What matters is what the Constitution limits the states in their ability to be able to exercise power. Because if the state exceeds the power authority statutorily conferred upon them by the Constitution of the United States of America, it doesn't matter why. What matters is that they did it. And that the fact that they did it means that it's unconstitutional. So every one of these states, right, the state of Washington, Michigan, Pennsylvania, North Dakota, Connecticut, every one of these states that relied upon an inferior state statute to deprive a person of a right that they're guaranteed by the Constitution of the United States to go out and create a contract of guilt with people, all those contracts of guilt are all unconstitutional. Your conviction, brother, is unconstitutional because the state of Texas is one of those states that permits their prosecuting attorneys to charge by information or indictment by their discretion. And so the problem is that particular statute, right? That particular Texas state statute, it doesn't matter whether they used indictments by a grand jury. For some people, if the law is unconstitutional, then everything produced from that law must also be unconstitutional. And as it stands today, any law that permits your prosecuting attorneys or public officials to decide who gets a constitutional right and who does not is unconstitutional. Period. And the way that we deal with an unconstitutional statute, according to the United States Supreme Court, Norton versus Shelby County, is it's not unconstitutional from the moment deemed such, but rather from the moment it was created, as though it was never created at all. It was always unconstitutional. The state of Texas cannot create a law that allows for their public officials to say, you're going to get a constitutional right, and you are not, because that's a violation of the 14th Amendment through Article 4. And as a result, every contract that the state of Texas creates is unconstitutional because it's relying upon an unconstitutional statute.
The truth comes out. When the truth comes out, you can run, but you know it's ending. At the bottom of the grave, you're digging out. When the truth comes out, yeah, you know this is just the beginning. Lies crumble down when the truth comes out. Crumble down when the truth comes out.